Hello, everyone. This is Amber Walsh with McGuire Woods. I am a partner in the healthcare group and chair of the McGuire Woods healthcare team. I'm here with my partner, Bart Walker, who also is a healthcare transactions expert and leads our group in our Charlotte office. And in a minute, I will let Bart introduce himself and his practice. But before we kick off today's webinar, which is entitled A Healthcare Industry Primer for Private Equity Professionals, I need to take care of a few little housekeeping things. So first of all, we are pleased that you've joined us today. Know that many of you on the phone are in-house lawyers who are seeking CLE credit. And if that's the case, you may follow up with Lexi Blainer. She will be sending a follow-up communication after today's webinar to make it very easy for you to make sure that we can assist you in the documentation you may need to get your CLE credit. Likewise, Lexi will be sending to you in a follow-up communication all of today's materials, primarily the slides that we will be going through today. And then lastly, Bart and I want to invite you to raise questions on the fly during the webinar. If there is time at the end, we are very happy to answer those questions. It's fun. It keeps things, it helps us to ensure that we are answering the questions and addressing the issues that are top of mind for you. So please feel free to submit a question during through the chat function on the webinar interface that we're using. So lastly, before I turn it over to Bart for a quick introduction, I just want to tell you very briefly about McGuire Woods Healthcare Private Equity Team. Many of you who are joining us today are clients or are aware of our healthcare private equity practice at McGuire Woods. It's something we're very proud of, and it is a great intersection between our very strong private equity, M&A, debt finance, and tax professionals, and the healthcare regulatory team as well. And we chose to do this webinar today because we are constantly speaking, writing, hosting conferences that are at a more intensive kind of upper level. But as more and more private equity investors are dipping their toe into healthcare, as more people are making the shift into healthcare investments as individuals, we recognize that there was a need for a primer. So this is very much intended to be a 101 level introduction to the key healthcare regulatory schemes. And we've set this up in a framework that hopefully will help you determine, based on the type of business in which you are investing or in which you may presently be operating, the key regulatory schemes that apply. But we will be doing more in 2019 with upper level webinars. And then we are hosting our Healthcare Private Equity Conference February 20th and 21st in Chicago. And any webinar attendee today is welcome to join us at a discounted price. If you're not already planning to go, please reach out to Lexi or Bart or me. Our contact information is at the end of the slides. So with those housekeeping details behind us, Bart, let me just turn it over to you for a few minutes to describe your practice and how you hit healthcare private equity, and then we will get into the meat of the webinar.
Sure. Thanks, Amber, and welcome to everybody. Thanks for joining us today. My practice is very similar to Amber's in the sense that I'm in our healthcare group and spend the vast majority of my time doing M&A and transactional work, primarily for healthcare companies, including healthcare providers, private equity funds, and debt finance sources. If you're not familiar with our firm, we're one of the top healthcare practices in the country in terms of size, and I think Amber alluded to this earlier. One of the places where we make a lot of our, where we spend a lot of our time and we feel like where we add a lot of value is the intersection of healthcare, private equity, and debt finance. We represent parties on all sides of those transactions, and so we feel like we have a pretty good sense of where the market is, particularly in the dozen or so key niches and verticals where we concentrate a lot of our time. And you'll see them in a lot of the sort of popular investment areas, from dental to derm to urology, radiology, pain management, ASCs, dialysis. And as you'll see as we go through this, this is really intended to be a kind of a 101 level primer, but we spend the rest of the year pretty down in the weeds in the various niches. So as you're looking at opportunities, we do spend a lot of our time off the clock just talking with people about the investment opportunities they're seeing in different niches. So we certainly welcome that conversation outside the context of this webinar. But please do submit your questions. We'd love to make this as accessible and useful for you as possible. So with that, Amber, I'll turn it over to you for the substance.
Great. Thank you, Bart. So let me just kick off by describing the agenda and format for today. We thought it would be useful if we start by orienting ourselves in a transaction. And while this may be transactional focused, the reality is that every single one of these regulatory schemes applies not just at the transaction phase, but throughout the lifetime of operating the particular healthcare business. And we'll go into that as we move along. But we think about, and we believe that a lot of participants in the industry think about the players, the potential acquisition targets, in one of three buckets. Either traditional true healthcare service providers, and we'll kind of get into what that means in a minute, the healthcare light providers, revenue cycle management, et cetera, and again, we'll get into that, and then the med device, life sciences, pharma, those three big buckets. We will talk about that in a minute and how that plays into each one of these regulatory schemes. But the format for today will basically be to take each one of the set of laws that you see on this slide and apply it to each one of those buckets, but with a heavy emphasis on healthcare services. And here's why. We believe what we have seen moving in the market for the last several years are PPM businesses, physician practice management businesses, dental practice management businesses, other healthcare services like surgery centers, imaging, lab, et cetera. Certainly, we have been involved in the other types of healthcare targets, but today's focus is, as advertised, more heavily focused on the healthcare services part of that. So we're then going to go through each one of these big buckets: fraud and abuse laws, corporate practice of medicine, licenses, permits, and CON, HIPAA, antitrust. We're going to talk about how it will impact your deal structuring and also what it means for key diligence items. So just a little bit more as we move on to the next slide, just a little bit more about these three buckets of target types. Within healthcare services, it can be further broken down into two buckets. And I'm actually going to toggle between two slides here because I think it's most helpful. So there are basically the big buckets within healthcare services would be professional businesses and facilities or other non-professional businesses. So what does that look like putting them side by side? And that's why I'm toggling between these two slides. So all of the three big business types, healthcare services, healthcare light, and pharma med device, and both sub-buckets of healthcare services, professional and non-professional, will be subject to fraud and abuse laws. And we'll talk about that in a minute. But a lot of these other regulatory schemes that we're going to be talking about today do not apply to all businesses. So, for example, we are going to be spending, Bart is going to be walking us through corporate practice of medicine considerations. It is a big component of what private equity investors, lenders are looking at to understand for structuring their transactions. So as this chart shows you, corporate practice of medicine considerations are always applicable to any professional business type, be it physicians, dental, nursing, chiropractic, you name it, PT, whereas the facility ancillary businesses typically do not involve professional services, not physician services. They're more facility type services like imaging lab, et cetera. And while they have their own set of applicable laws, we don't worry about CPOM. And Bart will remind you of that when he gets to the CPOM portion of the presentation. So here's what it means for structure. In a business that is a professional business, and depending on the state, so this is a sweeping generalization I'm about to make, and Bart will go into it in much greater depth, the end result of the state-level corporate practice of medicine restrictions is that the non-physician or the non-dentist, whatever that professional business is, the non-professional cannot directly invest in the business. So we use other structures that have generally been accepted so long as you're appropriately abiding by various important considerations that Bart will talk about. It's important to understand this now at the front end of the webinar before we even talk about the fraud and abuse laws, because they are slightly different structures that come into play in these healthcare private equity transactions. So corporate practice of medicine restrictions on professional businesses only will often necessitate the use of an MSO-PC structure that Bart will describe in more detail, but that for purposes right now of orienting yourselves in the different types of business models, the most important thing to understand is that the non-professional is largely investing in the administrative services provider. It goes by a number of names. You could call it the MSO. That's the most common, Management Services Organization. The administrative service provider, lots of different names it goes by, but MSO is our preferred terminology. And so consequently, because that is where the non-professional invests, that means the revenue stream, moving on down to the next part of the chart, the revenue stream is administrative services fees. It is not a direct distribution of the service provider's revenue. And we've given a couple of examples on which fit into which of the two sub-buckets of healthcare services businesses. So moving back here really quickly, just the last few things to keep in mind, when we refer to healthcare light, so moving out of the healthcare services and those two sub-buckets, healthcare light, and there are a lot of different terms for that, but we're using our terms, generally includes businesses that provide services to healthcare services businesses. So that would mean revenue cycle providers, staffing companies, health IT businesses, all compliance review organizations, valuation businesses, anything that is working within the realm of healthcare, but generally not touching patients and not taking direct third-party payer reimbursement risk. That is the big distinction between a healthcare services business and a healthcare light business. And then that last big bucket I had mentioned is life sciences, inclusive of med device and pharma. Those tend to be businesses that are heavily IP dependent. That's where a lot of the value comes in. And it is, of course, conceivable that in any acquisition target, there will be components of multiple businesses in one acquisition target. So you have different regulatory schemes on top of different business considerations to work through. Because we're keeping this at a 101 level, we're going to assume there are three big buckets. And of course, different PE investors have different appetites for different flavors of healthcare investments. We know many investors are just not comfortable with reimbursement risk, with the malpractice risk, with that sort of all-in healthcare services investment, and dip their toe into healthcare they're investing in one of the other buckets. So these buckets require different approaches to deal structuring and diligence, and that's really what we're talking about here. This slide is just an overview, again, of the 5 big regulatory schemes that we already mentioned. So let's get into the meat of the first regulatory set of laws that we need to be aware of: fraud and abuse statutes. You will often hear people refer to all fraud and abuse laws as the Stark Law. And that's because it's the most famous. Pete Stark made it famous years ago and continues to weigh in with commentary on his namesake law periodically. But there are other fraud and abuse statutes. And so just to give you a preview of what we're going to be looking at, right now we're going to talk about the Stark Law. We're also going to then be talking about, in a minute, the anti-kickback statute. And I'll get there in a minute, and I will orient you on how they are different. But I think it's important to understand a few key distinctions up front. Many people, quite often lenders or first-time private equity investors, are most nervous about Stark. And on the one hand, Stark is very strict. There is no flexibility within Stark. If there is a compensation arrangement between a physician and an entity to which he or she is referring Medicare or Medicaid business, it is strictly, absolutely prohibited unless every single element of one of the Stark Law's exceptions apply. So in that way, Stark can be nerve-wracking in its lack of flexibility. But most healthcare attorneys, I think, find the anti-kickback statute, the other fraud and abuse federal statute we're going to talk about, to be even more daunting and concerning because it is much broader in its application. While we'll talk about that statute in a minute, let's finish up with Stark before we do. What makes Stark limited is that it only applies to Medicare or Medicaid business, not even other government payers, just Medicare and Medicaid, and it only applies to referrals for certain types of businesses. These are generally what the government years ago had determined to be the types of referrals that are most subject to abuse. Lab, which is how Stark started, imaging, PT and OT, DME suppliers. There is a list of DHS, and when we send around the slides, we'll make sure the full list is included in that deck. Notice, and this is very important, notice what's not in that list. What's not in that list is professional physician services. So if you are an investor who is looking at a PPM business, the basic physician services, the personally performed sweat of their back services, is not subject to Stark analysis. The only time you're looking at Stark in a PPM business is if they have some of those ancillaries within the practice, if they have lab or imaging in the practice, which does occur with some degree of frequency. But the very basics of physician services are not part of Stark. Likewise, ASC services, ambulatory surgery centers, dialysis facilities. There are a whole host of healthcare services that are not subject to Stark analysis. As noted on here, the penalties of violating Stark are harsh, and so it's really important, obviously, to take great care to ensure that any referral of a physician or Medicare Medicaid business for any of those DHS services meets an applicable exception. I'm going to go and talk about AKS very quickly to contrast it with Stark, and then we're going to talk about a couple of ways that these two laws and some state laws, which rounds out the big bucket of fraud and abuse laws, how they come up in healthcare private equity transactions. So moving on to the anti-kickback statute. As I mentioned, it is much broader. It is much broader in that it applies to any type of healthcare service. It's broadly applicable. It also applies to any government business. So beyond Medicare and Medicaid, now TRICARE, Champus, even some state workers' comp is funded by the federal government. And there's also a much broader universe of people that can violate this statute. It is no longer just the physician and the recipient of the referral which can violate STARK. Anybody that is involved in a scheme that the government has determined violates the anti-kickback statute because it is intended to compensate or reward these referrals can be in violation of the anti-kickback statute. And that's what makes it broader and generally where many professionals, including those of us at our firm, spend a lot of time working through issues. But here's the Stark law exceptions. The anti-kickback statute does have a number of safe harbors where if you can meet every element of an applicable safe harbor for your arrangement, then that particular arrangement will be immune from prosecution. But what happens if you don't meet every element of a safe harbor? That's always the first choice, of course, and we spend a lot of time trying to structure transactions consistent where we can check every box of a safe harbor. But if you don't, unlike Stark, arrangements that do not fall within a safe harbor strictly still might be lawful. It simply means that the arrangement now must be analyzed for intent. The OIG on numerous, hundreds if not thousands of circumstances has publicly, privately acknowledged that there are many arrangements that may involve government pay that may not meet a safe harbor, but that are nevertheless lawful. So that requires having good lawyers to help you work through these things and understanding generally the types of things that can trigger OIG concern. Before I give you a couple of those examples, I just want to do a quick reminder about state-level fraud and abuse statutes. Most states have a self-referral law that is quite similar to the Stark law, and a kickback statute that is quite similar to the federal anti-kickback statute. Not all states do, most do. Many states go farther than the federal versions in that they apply to any payer. And so that's why it's very important that when you are looking at a business, or if you are an in-house lawyer involved in a business, if you happen to not take government pay, you still may need to worry about state law because your state law may very well prohibit the same type of arrangements for all types. And that's because commercial payers are also concerned with abuse, and states are inclined to protect all payers in the system. So how does the fraud and abuse statutes impact a healthcare services deal? And again, hearkening back to those three big buckets at the beginning: healthcare services, healthcare light, and life sciences, med device, pharma. I'm going to spend most of our time here very quickly going through some examples because I want to make sure to leave time for Bart's corporate practice of medicine and other legal buckets. Structuring considerations. Very basic things like purchase price determination. Generally speaking, assuming that you have fraud and abuse statutes that are applicable to your business, and most do, generally speaking, you will want the purchase price to be fair market value. And ideally, getting to the next bucket, paid in full at closing. However, It is becoming increasingly common within the healthcare private equity deal world for a variety of reasons. There are a lot of business factors pushing in this direction. It has become common to have a secondary payment of some sort or a holdback of some sort. And there are a number of considerations. I consider that to be a 2.0 level topic that we will address in a 2019 webinar. But just know that the Stark Law and the anti-kickback statute and your state laws are going to be a key factor in determining how you may structure an earnout or how you may choose to avoid an earnout because it's simply the risk involved doesn't work for your business. The next piece that it impacts your structuring is your management and other service relationships. I mentioned previously an MSO-PC structure. Bart will get into exactly what that looks like in the next segment of this webinar. But when you are in such a relationship, quite often the physicians will be owners in the MSO alongside the private equity investor. That means that fraud and abuse laws, and really even if they're not part of the MSO, frankly, but in particular, if they are, it means that you really have to be careful about those management relationships. And so depending on whether or not there are Stark services involved, will determine whether or not both Stark and kickback apply or if only kickback will apply. And then in PPM and DPM deals, so physician practice management deals and dental practice management deals, the ongoing compensation paid to the physicians will definitely be impacted by the Stark Law. The Stark Law is one of the most frequently looked at exceptions under Stark in that type of business is the in-office ancillary services exception. That is the exception that allows physicians, when properly structured, and they're very, very complicated structuring rules, when properly structured, to have lab, imaging, DME within the practice, so long as there are very particular rules that are abided by. And not only that they may refer to it, but then once they've referred, revenue comes in from the payer, that revenue is then distributed back out to the physicians in their ongoing employment compensation. And that Stark Law exception speaks very specifically to how it may be distributed out to the physicians in compensation. And that's going to become a big part of structuring your transaction, where the dollars move at closing. The private equity investor has invested through a management relationship in a PPM business or directly in a non-professional business, and now the physicians have different and altered revenue streams. And it becomes very important that we get all of the revenue streams to the physicians to be compliant with Stark and anti-kickback statute. Last note on diligence before I turn it over to Bart. The fraud and abuse statutes are the bucket of laws that we use when we are analyzing referral source relationships. And surgery center tenant relationship with a landlord physician. There is a Stark exception for that. There is a similar anti-kickback statute safe harbor for that. So we spend time in diligence working through to make sure that we are comfortable that that relationship is appropriate and does not create undue fraud and abuse statute risk. All sorts of other referral relationships, consulting arrangements, REIT agreements if you're an imaging facility, innumerable referral source relationships. And it's a critical component of diligence. It's also important analyzing how they've set up their ancillary investments so that the money in from a payer gets distributed out properly to the referring physicians. And so we've listed here imaging, lab, ASCs. That is a key component of the diligence. I'm going to turn it over to Bart to talk about the next biggest regulatory scheme under which we need to be analyzing healthcare private equity transactions. But before I do, just a last note is that I mentioned earlier that fraud and abuse statutes largely apply to government pay businesses and healthcare services businesses. However, we also have to be mindful that these laws also impact healthcare-like businesses and life sciences, med device, and pharma deals. We're not going to spend much time at all in this webinar, as I mentioned at the beginning, in those types of investments. We will do that in 2019 as we get into the rest of our webinar series. But the important thing for you to remember is that if there's government pay in a relationship between a healthcare-like business and an actual provider, a referral source, that is where it becomes much more applicable for the fraud and abuse laws to be analyzed and be a key part of structuring. One example to round out this part of the dialogue is, and this is a classic one that many people know about, med device manufacturers' relationships with their referring physicians. If there is a relationship beyond simply choosing that particular spinal screw for the spine surgeon surgery, there is a relationship that goes beyond that, a consultancy, a royalty agreement, anything like that. Fraud and abuse is the collection of laws that we use to analyze the appropriateness. I'm going to end the fraud and abuse component of the webinar there and let Bart talk about the next several set of laws, and want to just invite you to, as we're moving out of this component of the webinar to the next, want to again invite you to add questions in the question boxes. We see a couple coming in right now, and hope to be able to answer those before the end of the webinar if there is time. We promise that if we don't get a question answered due to time constraints, we will follow up with you individually and get your question answered, because that's what this is all about. That's why we're here. Bart, I'm turning it over to you.
Okay, great. Thanks, Amber. Well done. And obviously, every deal we look at, every structure we look at has to go through those two filters, both Stark and anti-kickback statute. And sometimes that's an easy process. More often than not, it's a pretty complicated one. So jumping into the next topic, corporate practice of medicine. Again, going back to the original slide where Amber gave the overview of how we break down healthcare, healthcare light, healthcare services, facility-based healthcare. This is squarely in the arena of professional services. So it's generally not facilities. It's generally not healthcare light. These are often structures where it's either a physician or a dentist, and by extension, optometrists a lot of times, physical therapists, chiropractors, veterinarians, most of the learned healthcare professions who are subject to licensure in most states have some form of corporate practice restrictions. And what that means is I'm not a licensed doctor. I'm not a dentist. Neither is Amber. Most of you on the phone are not either. The concept at the most basic level is we as non-physicians cannot own or operate a physician practice. And the policy reason behind that is obviously if these people are licensed, there's a very good reason for that. You don't want people who are not licensed to impose some sort of business objective or other objective other than healthcare or patient, the best interest of patients on the practice. So that's the policy that drives a lot of these laws. They come from a few different places. Some states have statutes. Some states have very old statutes and old case law. It's not uncommon to see cases on the corporate practice of medicine from the 1920s, 1930s, 1940s that really have not been touched since then. Depending on what state you're in, this can be a hotbed of activity for litigation and dispute. Other states, not so much. I can go into a little bit of analysis in a couple of slides. But suffice it to say, the corporate practice of medicine doctrine is a very big issue we have to deal with, and it primarily impacts structure in the sense that if I can't own a physician practice or I can't own a dental practice, well, then how do I invest in that? Or how do I get some economic stake in that without exercising actual control or having ownership of the stock of one of these practices? And so what the industry and people in the space, healthcare lawyers, have come up with to comply with corporate practice of medicine restrictions is what you'll often hear called the MSO-PC structure or an MSO structure. And what that means is you're effectively bifurcating the business of a medical practice into two pieces. One is the traditional professional corporation, PLLC, that actually manages and runs the clinic. So anything clinical, anything that touches patients, any decisions that impact patient care are made by the professional entity. The other piece of it is the management services organization. That takes care of all of the business functions of the practice. It takes care of management, staffing of non-licensed individuals. They take care of budgeting. They take care of AP, payroll, billing and collections, et cetera. And so that's really what you're doing, is bifurcating the business into two separate entities so that there is effectively a wall between the people who are making the decisions that impact patients on the one hand and the people who are making decisions that impact the business on the other hand. That's the most basic principle. I will say that a lot of times it's more art than science, in the sense that most states do not have really, really clear guidance on these specific structures or what you can and can't do. So a lot of times as lawyers, we're forced to take a particular situation, take the existing case law, or sometimes it's a medical board advisory opinion or an attorney general opinion, and try to interpret that in a way that allows these structures to come together in a way that achieves the business objectives that were originally set forth without tripping over these corporate practice restrictions. So I tend to be a very visual person, and so this is one way of thinking about the corporate practice of medicine and how an MSO-PC structure would function. And so here you'll see we've got two separate entities. You've got the MSO, which can be owned by anyone. It can be owned by physicians. It can be owned by non-physicians. It can be owned by private equity funds, et cetera. So that's kind of the business side of it. And then the medical practice is owned by one or more physicians or veterinarians or dentists, whatever type of practice it is. So at least nominally, that practice needs to be owned by a licensed individual in most corporate practice states. And I would say probably 35, 40-ish states have some form of corporate practice restriction, so it's quite common. So in most states, we're stuck with this type of structure. The management agreement is really the key link between these two entities. It's typically a very long-term management agreement. It's hard to terminate. It effectively parses out control as between clinical matters and business matters, and that's really the key operational document here, the management agreement. There's a lot of time that's spent on that document. Some of the key issues that we tackle involve how to actually set the fee. So some states have fee splitting prohibitions, which would prohibit a percentage-based fee. So you may have to resort to a flat fee. You may have to resort to a cost-plus model. And you may even want to go get a third-party valuation to validate that the fee that you're charging is consistent with fair market value. So there's always a lot of discussion around the fee, how to set that, and what goes into that. Number two, just again, the amount of control that the physician has, what decisions they're allowed to make, what decisions the MSO is allowed to make. Again, is going to vary by state. Typically, the MSO will hold all the assets that it's allowed to own, which is basically everything except the clinical assets. And what I mean by clinical assets are patient records, typically is the big one, and then in some states, certain pieces of equipment that actually are used in the treatment of treatment of patients may actually have to be owned by the practice entity. But that gets a little bit more into the nuances of the state-by-state analysis, which is also another reason why this is tricky and sometimes more art than science, is it is a state-by-state analysis. So corporate practice doctrines are state-based creatures. So in every state, you've got to you've got to run through this analysis as well if you're going to try to invest in one of these practices because you can't own it directly. So here's how we think about it just from an analysis perspective, and going along with the theme that Amber presented earlier, just some structuring considerations and then some diligence scenarios involving corporate practice. So the first question you have to ask yourself is whether or not this is even a CPOM state or a corporate practice of dentistry state or whatever practice you're looking at. If it is, then you have to try to identify the guardrails. And as I said, that's not always clear where those are. It's not altogether clear a lot of times what fee structure you can have or how much control you can have over that practice via operation of the management agreement. So down below, I've just listed a few of the hot topics that we end up spending a lot of our time talking about. So number one is a stock transfer restriction agreement. Sometimes it's called a succession agreement or a continuity planning agreement. That's the agreement that sets forth the conditions under which the ownership of the practice may be changed, either at the request of the MSO or because of the occurrence of some event like losing your license or being convicted of a felony. So that's one agreement that, depending on what state you're in, that could be a very tightly drafted agreement or it could be very loose, depending on what the courts and advisory opinions in those states have said. Second, whether or not the MSO would have a lien on the assets of the practice. Most states, that's become pretty typical and pretty commonplace to secure payment of the management fee. Although I will say in some states, which for now shall remain nameless, it's a closer call or an item more in dispute. Negative covenants, so to what extent can the MSO prevent the practice from doing certain things, like selling itself, selling its assets, entering into new employment agreements with new physicians, terminating physicians. All of those questions are very much within this bucket. Whether there's a termination or breakup fee, we don't often see that, but that is a tool that we use in some places where the state would allow it or at least not prohibit it, is if that management agreement were to terminate, then there could be some fee payable either by the practice or its owners. The idea being that because all the economics of the practice are flowing through that management agreement, if that management agreement were to be terminated, that would be a very bad day for everyone involved. So there ought to be some disincentive to that happening. And then finally, some states will actually allow you to have officers or managers of the practice who are not licensed individuals. So you may actually be able to put a business guy in there. That again varies by state, but something to consider when you're looking at this structure, how to put these things together. And of course, if it's not a corporate practice state, the next question you ask is, well, does direct ownership make sense? In some states, the answer is yes. Some states, the answer is no. We have had clients who have looked at states where they could technically own the practice directly, but for purposes of consistency with the rest of their platform or for other reasons chose to put it in a traditional MSO-PC structure. So it's not at all a foregone conclusion, although all other things being equal, I'd prefer to own something rather than only have a management agreement at the end of the day. Some diligence scenarios. Number one, I think you have to look and make sure that the practice has actually been doing this properly in the past. Every once in a while, we'll see a practice where they've actually admitted an impermissible shareholder or owner into the practice. The typical situation would be the spouse of the main practitioner in the practice. That's not allowed a lot of places unless they're also a licensed provider. So that's one thing to check from a diligence perspective. There's no guarantee that they've been doing it correctly all along. Then obviously the identity of those friendly owners becomes very important. So because the practice will be owned by the physician or the dentist, you need to have a very high degree of trust in that person. The challenges that we've seen have occurred where the physician or the dentist becomes sideways or antagonistic to the owners of the MSO, and when their interests are not aligned, it's very much a recipe for disaster, particularly because the law is not at all settled in a lot of these states. The opportunity for some sort of a dispute over the management agreement or over the structure itself is a key risk in these structures. And then finally, I just put a note here. The complexion of the corporate practice structure put in place can change or can vary based on whether it's a de novo development or whether it's an acquisition situation. We find that the pressure points are a little bit different when you have a seller who's getting a big check and then being asked to stick around in the structure post-closing versus one where you're really helping put someone in business from the ground up, or you're using one of your truly friendly or truly insider physicians to build a practice around them. So it's something to keep in mind just from a diligence perspective going forward as you put these structures together. Okay, so next, licenses, permits, certificates of need. So this is switching over to the facility side, although you will see these from time to time in physician practices or even dental practices or veterinary practices where the practice itself will own an interest in an ASC, less commonly in a hospital, although that does happen. Laboratories, CLIA services are often provided, or CLIA waived, as they're called, services are often provided within the four walls of a practice. So that's something to keep an eye on. There's also individual provider licenses, obviously, medical licenses, dental licenses. Those are quite common on the provider side, both in the facility context and on the healthcare provider business side. And then finally, there are certificates of need, or sometimes they're called certificate of public necessity, or they have different names depending on what state you're in. But the idea is before you open a new facility or offer a new healthcare service or purchase a new piece of healthcare equipment, the state actually has to approve that. And at last count, I think it was around 30 or 35 states have some form of CON still in place. Again, that's a creature of state law. So what all this means from a transactional perspective, there's a few things. One is from a structuring perspective, you need to be mindful of what the change of ownership process is for these licenses. Some of them, it's a very long lead time. Like Florida is notorious for certain types of licenses having a 90-day lead time, which in the transactional world is an absolute lifetime and a half. So you have to kind of build that into your process where you need to find some workaround that still complies with law. So there could be no easy solution in some of these places. So that's one a process item to keep one eyeball on. The second is a lot of times in connection with licensure applications or change of ownership applications, there may be information disclosures, and depending on the identity of the buyer, if you're a PE fund, if, for example, the state was going to require you to turn over names, social security numbers, balance sheet, and P&L for every one of your limited partners in your fund, that could be a very big problem. So you want to know up front what the disclosure requirements are for the licensure application, whether it's a change of ownership or a new application. And then finally, sometimes there's public hearing requirements, and that can be a very big deal depending on how quiet or confidential the transaction is, depending on what type of interference you expect in the public eye. That can be something that can really cause some problems. We see that particularly in hospital transactions, where if there's a public hearing requirement before a public hospital is sold. We've seen it in that context before. We've also seen it in the CON context. Like, for example, Tennessee has a public hearing process as part of a change of ownership or new application for CONs for surgery centers. That's just one example. From a diligence perspective, the things we like to look at are past survey results. So those are usually a dead giveaway if the state has come in and found some serious problems. Usually they're operational in nature, so less of a legal question, but those are things that we always ask for, and we want to see clean surveys. The other thing to look for is what's not there, what's not in the data room. Maybe I shouldn't be so surprised, but I'm always surprised that sometimes targets actually don't have the right licenses in place at all, and I don't think it's intentional. I think they've just simply overlooked it, or perhaps they've grown more quickly without really dotting all the I's and crossing the T's, but they could have a gap in licensure, so that can be a really big problem. Second, your expansion can be limited depending on what the state's licensure and CON requirements are. So for example, in North Carolina, where I am, although we work on transactions all over the place, just by way of example, you need to get a certificate of need before you buy a new piece of imaging equipment or a new MRI machine if it's over a certain dollar figure. You'd also need a CON if you wanted to add an OR to your surgery center, for example. And so that's one thing from a business perspective. If you're looking at buying and building, you need to take that into consideration that your expansion opportunities might be limited depending on how difficult it is to get a certificate of need or a different type of license. And then finally, we always like to ask about relationships with regulators. So if we find out, for example, a practice has a very, very bad relationship with the regulators, or there's somebody sitting on the board currently who is the arch enemy of the founder of this physician practice, that's usually something you'll want to dig into a little bit more. On the other hand, if there's somebody who is very, very friendly with one or two or more people on the dental board, that can be a very good fact for you, particularly in states where there is regulatory obstacles or challenges you need to navigate. So in New York, for example, that would be an important thing to know. Same is true for the state Medicaid programs and Medicaid-heavy businesses. If the practice has a very good relationship with the Medicaid agency in that particular state, that can be a very good thing, and the converse is also true. Okay, I know we're running a little short on time. I do want to get through all this, so let me just zip through real quick on HIPAA. I know there's a lot of confusion about this, so this breaks it down, and I think this portion of the slides I intentionally made a little bit more detailed so that you could use it more as a resource to look back on. So HIPAA, as you all know, is the key law that impacts the protection of patient data or patient information. And it's very specific on how you are able to share that and what you can do with that information. Again, I'll zip through this very quickly. PHI stands for Protected Health Information, and that includes health information plus some identifier. That means something that you can use to identify a patient. And that can be anything. It can be a social security number, it can be an address, it could be a picture. So you have to be very, very careful. PHI can be lurking in all kinds of different places. The key takeaway from this that I would give you is if there is any kind of health information, run it by your privacy officer, run it by your lawyers before disclosing it, because once the disclosure has been made, it may be too late. And that includes emailing things. Like we would get emails all the time from people who just send us patient information incidentally without even realizing it's in the attachment. And email is not an okay way to send that stuff generally. There are some safe harbors for sending encrypted files and some other ways you can send those, but you just have to be very, very careful about how you do that. Here's a HIPAA compliance top 10 list for you. I won't spend the time going through these, but this is something for you to keep in your back pocket. I think this is, helpful just from a diligence perspective, or if you already have businesses that are covered entities from a business, from a HIPAA perspective, that you can use as a sort of a checklist or a mental checklist to make sure you're doing things right. It's not all-encompassing whatsoever, but it's at least some very basic top 10 things that you ought to think about. So let me just try to bring this home for a deal perspective. So from a structuring consideration, there's not a whole lot you can do to structure around HIPAA. You're either governed by it or not. If you are an entity that uses, generates, stores healthcare information, or PHI as we mentioned earlier, you're likely going to be what's called a covered entity. And that means that you're going to have certain statutory obligations under HIPAA. You're going to have policies and procedures actually written down on paper that you can actually show people. You actually have to train your employees. You actually have to implement certain security measures, security safeguards. You have to have, there are a number of requirements that you have to satisfy. They're far outside the scope of this session at least. A business associate, on the other hand, is anyone who helps a covered entity perform some sort of business function. So for example, the classic example would be a management company or a billing and collections company. There, they likely are going to have access or need access to PHI to do their job or to help the covered entity do whatever it is they need them to do. There, you're also going to have HIPAA obligations statutorily. You'll also have a requirement to have a business associate agreement with the covered entity that sets forth the terms of engagement. In other words, if there's a breach of healthcare information, who's responsible for that? And it sets out different requirements between the parties of how you notify each other of breaches, how you return information, how you safeguard it, et cetera. So all of that, again, somewhat outside the scope of this conversation, but wanted to flag it for you as some common things that are talked about. From a diligence perspective, I would start with the top 10 list that we talked about on the previous page. That's a pretty good starting point. And you can get a sense very quickly of whether people are paying attention to HIPAA or whether it's really just not a priority for them. They should have written policies and procedures, both privacy and security policies and procedures. They should have some real serious training of employees, not just at onboarding, but periodically throughout the year or on an annual basis. You need to ask them if there has been any kind of breaches of PHI or impermissible disclosures. And then finally, I'd also ask if they've got insurance coverage. Increasingly, there are insurance products available that will cover data privacy breaches. So that's another thing to just keep in mind. So then finally, with the few minutes I've got left, I just wanted to touch very, very briefly on antitrust. This does come up. It comes up primarily in the context of sharing payer information. You have to be very, very careful about this. It's more acutely felt in situations where you have two competitors or two strategic companies who are talking to each other. It's a little bit less of an issue if it's a PE fund who does not already own a competitor and who is not looking to acquire another competitor in that market. The classic example is if during due diligence you were to share all of this payer information, call it you got practice A and practice B. They're both in the same town. Practice A shares all of their payer information with practice B. Practice B realizes that practice A is getting paid double what they're getting paid by all the major payers. Practice B calls off the transaction, says, no, we're not going to merge with you. We're not going to buy you. They then take that information and use it against the payers. That's what we call collusion. That is not something you want to engage in. There are ways to look at that information in a way that doesn't violate antitrust law. In particular, there are a couple ways of doing it. One is by having what's called a clean team, where you're actually creating a small internal group of people who are the only people who can see that material. The other way to do it is by hiring an outside third-party consultant who will take the information from each of the two practices in this example, run some analysis on it, and provide the analysis back to the parties without actually disclosing the pay rate information in a way that could prejudice their competitive situation. And then finally, I would just talk very briefly about structure. It is more of a process point on antitrust. If you've got a transaction that's above the Hart-Scott-Rodino filing threshold, which I think is 70 or 80 million bucks these days, you are going to have to do a filing with the FTC. Usually, the ordinary review period is 30 days. You can request what's called early termination to get that done in 10 days, but it does provide some drawbacks in terms of the filing being public versus not. So typically, if you've got the time and you've built it into your timeline, you look at that 30-day period, you start to get that period running, and then once it expires, you're okay to close. And then the last piece to keep an eye on is market concentration. And obviously, you will know if you're going to acquire somebody who's a major competitor in the same market that would result in you having control of that market or having effectively a monopoly. These are all issues, again, far outside the scope of this presentation, but definitely something that you should be aware of, particularly the disclosure of payer information, because we do see people stubbing their toe on that an awful lot. Even people who are very sophisticated and know what they're doing, that's an easy one to mess up inadvertently. So I think with that, Amber, I've finished exactly on time. I know we've got some questions, but we may want to follow up on those later. I defer to you.
Yeah, let me just say a brief word about the numerous excellent questions and how we're going to offer to follow up with you on each one of these. So we got about a dozen questions. They're very astute questions, and most of them go beyond the 101 level. So there is a category of questions about MSO-PC structures, the type of things the MSO is allowed to make decisions on, which I will tell you right now is very state dependent. It's also based on the parties' various elements, the relationships, the risk tolerance, and the state in which they are operating. There are other questions about HIPAA and identifying factors. Other questions, a very good question about in an MSO-PC relationship, where exactly is there a referral that would bring us into the fraud and abuse statute realm? And then there are questions about, are these types of services Stark services? These are great questions, and we're going to follow up with you on every single one of these, but I want to make you a promise and an offer. So the promise is the dozen or so people who raise these questions, you'll get an individual response from Bart and me. But also, if you did not raise the question, but you're curious about the topic, please send Bart and me a note, and we will be happy to separately discuss with you that same topic. And then again, I will just reiterate the offer that I made at the beginning of the webinar, which is to join us on our blog remotely, because we talk about a lot of these things frequently. We happen to have colleagues who published just yesterday on the blog an extensive piece on ophthalmology investments that touches on a lot of these. But then our conference, February 20th and 21st, we do deep dives into these issues for 2 days that go well beyond the 101. And in fact, we're going to have 3 panels that are 3.0 level PPM structuring, so MSO PC model issues. For those of you who are already in a physician practice management or a PT investment or one of these professional healthcare services investments and want to just take it to the next level, talking about fees, compensation, clinical decision-making, equipment purchase issues, et cetera. So that's the promise and the offers. And with that, I'm going to wrap it up with thanks for everybody who joined us today, and to Bart, and you'll be hearing from us very soon. Thank you.